Hello, everyone, and welcome back. Before we continue on, I will remind you again that I am not a lawyer and I'm not certified to practice law here in Vietnam. I'm just simply a guy from the United States who knows about the labor code. Now, we're going to go ahead and move on with this labor code series and talk about, I think it was Article 29. All right, so now reassignment of an employee against the employment contract. This was mentioned previously. I think it was in Article 35 or Article 36 is what was mentioned about Article 29. This is what it is. Now, this is something you really need to pay attention to because this also applies to what happens if the English Center shuts down because of, the virus and it's during the school year. So by law, if that happens, they're required by law to pay you the minimum salary of $4,685,200 a month, which is the Region 1 wage for Ho Chi Minh City. That's the Region 1 minimum wage. And I'll explain how they have to pay that here in a bit. So Article 29, Clause 1. Again, English and Vietnamese. Clause 1. In the event of sudden difficulties such as natural disasters, fire, major epidemics like COVID-19, implementation of preventative and remedial measures for occupational accidents or diseases, electricity and water supply failures, or for reasons of business and production demands, the employer may temporarily assign an employee to perform a work which is not prescribed in the employment contract for an accumulated period of up to 60 working days within 1 year, unless otherwise agreed in writing by the employee. So technically, if one of these things happens, then yes, by law, your employer can ask you to do something else that's not in your employment contract, but they can only ask you to do this up to 60 working days within 1 year. So if they ask you to do, if this keeps happening for, like 60 consecutive days, on the 61st day, they can't do it anymore. But I don't think it would go ahead and last more than 60 days. This means 60 total days within 1 year, not consecutive. But it can be either a mix of consecutive or regular days. The employer shall specify in the internal labor regulations the cases in which the employer may temporarily reassign employees against the employment contract. So again, in your employment contract, if they do not mention this, that means it's illegal. Again, just my opinion, but that's what I think this means. So, moving on. Clause 2. In case of temporarily reassignment, again, this was translated from Vietnamese into English, and the person who translated it, their English wasn't that good. That's the reason why it looks like that. And yeah, sometimes I correct this area, but it's not really this area you need to worry about. This is just for reference. This is what you really need to pay attention to because the Vietnamese version is right here. That's why in all these labor code series, I always have the English and the Vietnamese version at the same time. Moving on. Clause 2. In case of temporarily reassignment of an employee specified in Clause 1 of this article, the employer shall inform the employee at least 3 working days in advance. Before that happens, specify the reassignment period, how long it's going to be, like 1 day, 2 days, 1 month, what. And only assign works that are suitable for the employee's health and gender. And yes, now some people may go ahead and consider this to be sexist. Please don't. It's in the law, all right? It's not meant to be sexist. Because of the fact here, they are acknowledging that there are some works that are not suitable for some genders. There's only men and women for genders, but what they're saying is that there are some works that are not suitable for men, and there are some work that are not suitable for women. That's what they're saying. Now, just go ahead and mention really quick, yes, in the United States, I know that there are some people there that think that there are like 200,000 different genders. No, that's not how it works here in Vietnam. There are only 2 genders, man and woman, and there are female to male and male to female transgenders. That's it. Now, moving on. Clause 3. The reassigned employee will receive the salary of the new work. But, this is the big but. If the new salary is lower than the previous salary for the period that, you're going to be doing this, the previous salary shall be maintained, the previous salary shall be maintained for 30 working days. That's a tongue twister. The new salary shall be at least 85% 85% of the previous salary and not smaller than the minimum wages. So what this means is that if your boss makes you do something else that's not in your employment contract due to natural disasters, COVID-19 or something like that, that they must pay you your current salary for 30 working days. Then after that, if they continue to have you do that for another however long, excuse me, when they have you go ahead and do the other one, then that means, like beyond 30 days, that the new salary has to be at least 85% of the previous salary. Because if they try to pay you smaller than 85%, it's no good. And if your wages are so low, it should not hit below the minimum wages, which for Region 1, again, is $4,685,200. Because I remember the old price of $4,420,000, but then it raised 6%. I think it was June of last year. All right, now, Clause 4. In case the employee refuses to be reassigned for more than 60 working days in 1 year and has to suspend the employment, he or she shall receive the suspension pay. That's what I was talking about, the suspension pay, from the employer in accordance with Article 99 of this Labor Code. I'm pretty sure I talked about that. I don't remember. If not, I'll go over it again. Not a big deal. All right, so suspension of an employment contract. Moving on. And yes, everybody, you know that I still have a slight cold. That's the reason why I'm still coughing and stuff like that. I wanted to make these videos because they're actually important to me, and they're important to you too. I am taking a small water break. Just a moment. All right, now let's move on. So, Article 30, suspension of an employment contract. Cases of suspension of an employment contract. The employee is conscripted into the Army or militia, which won't happen to foreigners. The employee is held in custody or detention in accordance with the criminal procedure law. Don't do anything stupid. The employee is sent to a reformatory school, drug rehabilitation center, or correctional facility. Again, don't do anything stupid. Subclause D. The female employee is pregnant as specified in Article 138 of this code. Now, again, let me go ahead and specify this. This means biological female. Double D. The employee is designated as the executive of a wholly state-owned single-member limited liability company. No idea what that means. The employee is authorized to represent the state investment in another enterprise. The employee is authorized to represent the enterprise's investments in another enterprise, E and G. H. Other circumstances as agreed by both parties. G and H. Okay, right there. My apologies. Moving on. Subclause 2, or Clause 2. During the suspension of the employment contract, the employee shall not receive the salary and benefits specified in the employment contract unless otherwise agreed by both parties or prescribed by law. So your contract can't be suspended in any one of these circumstances. So as long as you don't do anything stupid, you should be fine. Now, moving on. I forgot to set my timer, so I have to go ahead and check and see how much my time is. 8 minutes. Okay, cool, which means I got about 15 minutes to go. All right, cool. So now I know about where I need to be, so we're going to go ahead and move on. All right, cool. So I got about 15 minutes left to go. Let's go ahead and see what the time is. So basically at about 17 after, I need to go ahead and wrap it up. All right, cool. So let's go ahead and do this. That's the reason why I set a timer at the beginning. This way I know when I'm supposed to wrap it up. Remember, I can only do 5 videos a day at 30 minutes max using this free software. So, yep. If only I had a subscription, I could make as many videos as I want in a day. Article 31, reinstatement of employees upon expiry of the temporary suspension of the employment contract. Within 15 days from the expiry of the suspension period of the employment contract, the employee shall be present at the workplace, and the employer shall reinstate the employee under the employment contract if it is still unexpired, otherwise agreed by both parties or prescribed by law. So, yeah, within 15 days from the expiry of the suspension period, I think this was also mentioned, Article 31, because I also mentioned 15 days. So, I'm pretty sure this is what I was also talking about too. So, essentially, you are required to be at the workplace within 15 days, and the employer will reinstate you if your contract is not expired, unless otherwise agreed to by law. Now, I know we've already covered Article 32, but I just want to highlight it again. Remember, Article 32, Clause 3, the part-time employee shall be entitled to receive salary, equal rights and obligations as a full-time employee, equal opportunity and treatment, and to a safe and hygienic working environment. I know we already covered that. I just wanted to say it again. Now, moving on. Article 33, revisions to employment contracts. This is also very important. During the performance of an employment contract, Clause 1, any party who wishes to revise the employment contract shall notify the other party of the revisions at least 3 working days in advance. This means that if your boss wants to change your employment contract, they have to notify you in 3 days before those changes take effect. If they don't accept it. Just my opinion. Clause 2, in case where an agreement is reached between the parties, the revisions shall be made by signing an annex to the employment contract or signing a new employment contract. Either one works. Remember the rules about the annex. We already went over that earlier. Clause 3. In case the 2 parties fail to reach an agreement on the revisions, they shall continue to perform the existing employment contract. This means that if your employer tries to change your contract in a way that's more favorable for the employer and you don't like that, you can say no, and they are required by law to follow the contract that you currently have with them. But in my opinion, this does not mean that they must conclude a new employment contract with you. That's the thing. Once your employment contract is done, they have 2 choices: to either sign a new one or let you go. And if they let you go, 1 month before your contract expires is technically, I think, when they need to let you go if you have a contract between 12 and 36 months. Now, moving on. So we've already talked about all of this. Now, here's the thing. We have about 10 minutes left until I wrap up this video. So we already talked about revisions to employment contracts. Let's see, what else can we talk about real quick? Work permit stuff. Let's see what we can do about work permit stuff. We already talked about that. Don't need that. That. Labor utilization plan. I know I talked about that. Redundancy allowance. Blah, blah. Invalid contracts. Blah, blah. Labor dispatch. Let's see. Dispatching agency. Hold up. Dispatched employee. Yeah, we don't need that. Basic and occupational training. I didn't talk about that, and it's actually in here, so we need to go ahead and talk about that. Okay, that's cool. Article 59. Now, I know I went ahead and mentioned this earlier about the basic and advanced occupational training, so since I already did mention that before, I think we should go ahead and talk about that. All right, so we got looks like about 10 minutes left until my 5-minute thing, so we're going to go ahead and do that. All right, cool. So here's Article 59. Chapter 4, Article 59, Occupational Training, Basic and Advanced Occupational Training. I know I talked about this before, but we're going to actually dive into it right now since we actually have a few minutes. All right, so Clause 1. Workers are entitled to have vocational training, participate in national assessment and recognition of occupational skills, develop occupational skills that are suitable for their desires and abilities. The state encourages eligible employers to provide basic and advanced occupational training for their employees and other employees by Subclause A, establishing occupational training centers or classes at the workplace in order to train, retrain, and develop occupational skills of the employees, cooperating with vocational education institutions in providing occupational training at basic, intermediate, and college level, and other occupational training programs as per regulations. Subclause B, carrying out vocational assessments, participating in the Occupational Training Council, forecast labor demand, and develop the occupational standards, organizing the assessment and recognition of occupational skills, developing professional capacity of employees. Now, here's the thing. In my opinion, Clause 2 applies to essentially factory workers, industrial workers, stuff like that. But Clause 1 can apply to everyone because that's what it says. You are entitled to have vocational training to participate in national assessment and recognition of your occupational skills, what you chose to do, develop your skills that are suitable for your desires and abilities. So yeah, it's right there. All right, now, moving on. And yeah, we already talked about that. So Article 60, responsibilities of employers for provision of basic and advanced occupational training and occupational skill development. Employers shall develop annual basic and advanced occupation training and occupational skill development plans for their employees and allocate budget for implementation thereof. Provide training for employees before reassigning them. So this, I think, can apply to everyone, not just factory workers. So develop annual basic and advanced occupational training, occupational skill development plans. That means like an annual, like once a year meeting where you sit for like 8 hours and then you get a certificate. That's about it. And you have to have a budget for that. So yeah, once a year, every English center is required to do this, and they don't do it because they don't want to spend the money on it. Clause 2. Employers shall submit annual reports on results of the basic and advanced occupational training and occupational skill development they provide to the provincial labor authority. And I bet you no English center does that either. I bet you. I will bet you 200 dong that no English center does that. I'm going to go ahead and take a water break. I've been coughing a lot. So 1 minute. Sorry, I talk a lot and I'm still a little sick, so that's the reason why I'm coughing a lot and drinking a lot of water. Anyways, let's move on. So essentially, I just pointed out a couple of things about the occupational skill development that the employers are required to do this, and that once a year they're required to do this for everyone. That includes English teachers. And yeah, no English center does this either. So yeah. All right, so moving on. Trainees and apprentices, training between an employer and employee, and occupational training costs. Okay, Article 62. Yeah, I'm just filling out the time now before I can go ahead and talk about other topics. That's why I'm talking about this stuff. Excuse me. Article 62, Clause 1. So, Article 62, occupational training contract between an employer and an employee and occupational training costs. Clause 1. Both parties must enter into an occupational training contract in case the employee is provided with advanced training or retraining at home or abroad funded by the employer or sponsorship from the employer's partner. The occupational training contract shall be made in 2 copies, each of which shall be kept by a party. Again, English and Vietnamese. Now, scrolling on up. Subclause 2. A vocational training contract shall have the following major contents. Subclause A. The occupation in which training is provided, like being an English teacher. Location, time of training, and a salary for the training period. Salary for the training period. Now, here's the thing. This could mean something like, some building at 9 a.m. and salary for the training period like $500,000 an hour. Let's just say that, Subclause C, the work commitment period after training. So essentially, if you commit to a period of 1 year, there you go. Now, the training costs and responsibility for reimbursement thereof. That's a little sticky area, but we'll go ahead and figure that out together. Double D, responsibilities of the employer, and subclause E, responsibilities of the employee. Remember, people, I said it before and I'll say it again. Anything that's a double D here is the D with the slash through it here. So double D, D with the slash through it. All right. Now, training costs, Clause 3. Move that up here. All right, so Clause 3. Training costs include those specified in valid documents on payments for trainers. Training materials, training locations, equipment, practice materials, other supportive expenses for the learner, the salary, social insurance, health insurance, and unemployment insurance premiums paid for the learner during the training period. In case the employee receives the training overseas, the training costs also include the traveling and living expenses during the training period. So, yeah, this means everything. What they pay and what you pay. Now, we're going to go ahead and move on. Because the way I see it, I've never heard of any English teacher actually doing this. So, yeah, but if this ever happened, you know what to look for. Again, English and Vietnamese. Now, moving on. So, dialogue at the workplace, collective bargaining and collective bargaining agreements. Now, this talks about union stuff. Union stuff is basically out of the hands of English teachers because, as far as I know, like I said, we're not allowed to have a union because we're foreigners and we're not citizens. That's the reason why we can't have a union. But let's move on. So this means basically union stuff. So I'm just going to go ahead and move on. We have at least a couple of minutes left before I have to go ahead and move on. So let's see what else I can find here real quick. Bargaining agreements, People's Committee of Provinces and Collective Bargaining, blah, blah, blah. Let's see. No. Let's see. Anything else? No. What's this? Withdrawing? No. No. Okay, yeah. All right, so we've already gone over that, and it's already about 15 till, so I'm going to go ahead and see really quick, like, what else I can talk about real quick before I have to go ahead and put this video online. Let's see, we already talked about that. Increase workload by seniority, personal leave, unpaid leave. Okay, well, we got about a minute left, so I can go ahead and talk about this. I think I talked about this. I'm pretty sure I did. If I didn't, I'll just fill out the time anyways and say it one more time. So we're going to go ahead and talk about Article 115 really quick, like, before we go ahead and move on with this series. Really quick, like. Okay, Article 115, English and the Vietnamese. Moving on, Clause 1. An employee is entitled to take a fully paid personal leave in the following circumstances, as long as is notified to the employer in advance. Marriage, 3 days. You're allowed to take 3 days off for marriage. Believe it or not. Now, fully paid personal leave. For marriage, 3 days. That means if you get married, they are required to pay you for 3 days. Marriage of his or her biological child or adopted child, 1 day. So if your kid gets married, you're allowed to take 1 day off and party. That's awesome. And you get paid for it. Ain't that cool? Now here's a sad part. Subclause C. Death of his or her biological or adoptive parent. Death of his or her spouse's biological or adoptive parent. Death of spouse, biological or adopted child, 3 days. Now, funerals can last anywhere from a day up to 7 days, so yeah. Clause 2. An employee is entitled to take 1 day of unpaid leave and must inform the employer in the case of the death of his or her grandparent or biological sibling, marriage of his or her parent or natural sibling. Must inform the employer. It says so right there. Clause 3. The employee may negotiate with his or her employer on taking unpaid leave other than the leave stipulated in Clause 1 and Clause 2 of this article. Now, I'm already at my time, so I'm going to go ahead and wrap this up. So, here's the thing. What we just talked about was basically some odds and ends stuff about the labor code. Now, what I'm going to talk about next in my next video is what's called Crime and Punishment series. This is parts in the labor code that specifically talk about, what happens if your employer decides to punish you and what you can go ahead and do about it. Okay, so we got about 7 minutes left. Wow. Okay, I didn't even know that. Awesome. Okay, this is what happens when you don't set a timer, people. This is what happens when you don't set a timer. All right, let's see. Labor discipline. Okay, let's just go ahead. Since we do have a few minutes left, let's just go talk about maybe a couple more articles. So, Chapter 8, Labor Discipline and Material Responsibility. This is a big one. Section 1, Labor Discipline. Article 117, Labor Discipline. Labor discipline comprises provisions in the internal labor regulations on the compliance in the respect of time, technology, production, and business management that are imposed by the employer and prescribed by law. Now, moving on. So read that, and then that. Remember, pause to read if you have to. So that and that. Now, moving on. Since I do have a couple of minutes left, yeah. Okay, so internal labor regulations. This might actually be a big one, and I don't know if I actually have time to get through all of this. Let's see. How much time I got left? Maybe... Yeah, I have exactly 5 minutes left. Let's see if I can do it, folks. All right, so we're going to go ahead and try and get through this as quickly as possible. Article 118, Internal Labor Regulations. Clause 1. Every employer shall issue their own internal labor regulations. An employer that has at least 10 employees shall have written internal labor regulations. That includes English teachers as well as staff of an English center. Moving on, Clause 2. The contents of the internal labor regulations shall not be contrary to labor laws or to relevant legal provisions. The internal labor regulations shall include the following key contents. Please pay attention to that. The contents of the internal labor regulations shall not be contrary to labor laws or to relevant legal provisions. So Article 118, Clause 2. Please remember this. Please remember this. So moving on, Subclause A, working hours and rest periods. Order at the workplace. And I'm just reading these out because I don't have a lot of time left. So please try to follow along, okay? A, B, C, and so on. So working hours and rest periods. Order at the workplace. Occupational safety and health. Actions against sexual harassment in the workplace. Double D, protection of the assets and technological and business secret and intellectual property of the employer. Cases in which reassignment of employees are permitted. Violations against labor regulations and disciplinary measures. Material responsibility. The person having the competence to take disciplinary measures. So yeah, all of that. It must have all of that. Clause 3. Before issuing or revising the internal labor regulations, the employer shall consult the employee representative organization, if any. Clause 4. Employees must be notified of the internal labor regulations, and the major contents must be displayed at the workplace where they are necessary. Right there. The government shall elaborate this article, Clause 5. Now, what this means is that the internal labor regulations must include all of this and must be posted, and the major contents of which must be displayed at the workplace where they are necessary. Now, they're necessary everywhere. So if your English center does not have this posted, in my opinion, obviously illegal. And remember, Article 118, Clause 2, the contents of the internal labor regulations, that means the rules of the English center or employer, shall not be contrary to labor laws or to relevant legal provisions. It says so right there. And again, it also says that in Vietnamese, Article 118, Clause 2. Boom. Right there. Now, I'm going to go ahead and wrap this up quickly because I'm pretty sure I don't have that much time left. Yep. Okay, cool. So I got 2 minutes left. I'm going to go ahead and say this. Please like, share, subscribe, comment on my videos. Please donate or tip me in cash, goods, or services. If you wish to do so, please go ahead and send me an email or send me a chat request to tuxedoshadow@gmail.com. If you are in Vietnam and have the Zalo app, please go ahead and join my Zalo chat group, as it is a group for English teachers who wish to know more about the labor code so they can protect themselves against unscrupulous English employers. Now, all I can say is have a good day, be safe, and I'll see you again in the next videos.